All right, counsel, my advice is that your client needs to contact the court. Thank you. We're done with this matter. All right, we're going to call the Balle case, case D08392-854. This is going to be a closed hearing. Anyone not related to the parties by blood or marriage is going to be excluded from the courtroom at this time. Counsel, if you could state your appearance for the record.
Yes, Neil Mullins, phone number 3544, with and on behalf of Cynthia Balle.
Andrew Taylor on behalf of Peter Mario Balle, bar number 8688.
Ballet is how they're pronouncing it?
Balle.
Balle?
Hotel Balle, yeah. With me.
Okay. All right. Counsel, I have read motion, opposition, supplement, reply,
So you did read the reply, then that's great.
and
You would have seen another reply, Judge, but I got it on Monday, so.
Well, his motion, his opposition.
hold on, guys. Hey, and first thing I want to say is I don't need any personal attacks between counsel. I mean, it's stressful enough that your clients are getting divorced and they're going through a custody fight without you two getting personally involved in the fray. Look, Mr. Taylor, your client makes a lot of allegations and provides little or no documentation.
Judge, the reason for that is that they've recently come to light from Mr. Balle. He's been talking to his kids, and they've suddenly started telling him about these events. So, other than the word of the kids, he's not fabricating or inventing them. They come directly from the
he's
children.
relying exclusively on hearsay from the children to raise these allegations.
That's correct, Judge.
Okay, and look, the bottom line is there's no way around it. He's been out of the house for a number of years.
Judge, that's not.
I mean, is it his contention that he's continued to reside in the marital residence for the last 4 years?
Judge, if you wanted to ask the kids, he comes home or has been coming home every single night.
Every night.
For the last 4 years?
Yes. Every night there, every weekend, on the weekends, watching movies, pizza night, everything. Just like a regular family, just I don't live there.
Swear him in.
You do solemnly swear the testimony you're about to give in the section should be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Counsel, you better warn your client if he lies to me and it comes out that he's lying to me, he's going to spend 25 days across the street in an orange jumpsuit every time he opens his mouth and lies to me. You want to take a few minutes and have a conversation with your client before I ask him a couple of questions under oath?
There's no need for it.
We're fine.
He's made these allegations
There's no need for the
in a filed document and provided no documentation to it.
I have talked to him about this, Judge.
Swear her in as well.
You do solemnly swear the testimony you're about to give in the section should be the truth, the whole truth, and nothing but the truth, so help you God?
His admonishment works for you, too. If you say a misstatement to a judge under a question, whether it's me asking a question, him asking a question, or him, it's lying to him, whether I ask it or not. And he can punish it. Thanks.
You understand that, ma'am?
Yes.
You made the allegation that he moved out of the house 4 years ago.
Yes, Your Honor.
Is that a true statement?
Yes.
In the last 4 years, how often has he spent the night in the marital residence?
I can't give you a number. He will come to the residence anytime he wants to. He will lay on the couch. He will go sleep with the children. He'll stay there as long as he wants to. He'll be gone for as long as he wants to. I've tried to tell him to stay out
How
of the
frequent
house.
is it? 2-3 times a week? 5 times a week?
Sometimes it could be 2 to 3 to 4 times a week. Sometimes he won't be there at all.
For how long?
Since 2005.
No. What's the longest he's gone without spending a night at the house?
He, in July of 2006, I believe it is, he did not come over or see the children for almost a month.
So 1 month is the longest. Now, I asked you, how long has it been, the longest he's been since he spent a night at the house? And you're telling me 1 month?
Well, it's been several months now since I filed for the divorce action, and I asked that he stay out of the house.
Well,
He has
what
not been-
qualifies as moving out?
He removed all his clothing. He has no personal possessions there except for the furniture in the home. He He also has a sworn affidavit on another court case that he has not been living in that residence since 2005. He was being sued in a car accident, and there's a sworn affidavit on file stating he does not live at that residence.
Is that true, sir? You got an affidavit in another case that says you don't live there?
I think it is.
All right. Well,
They tried to
counsel,
serve
now
me.
do you want to take a couple minutes and talk to your client before he answers my question about where he's living?
Just a minute, Judge.
Because they served me at the residence and I wasn't there, so they didn't properly serve it, and so the other counsel said that I didn't live in that location, that I resided in a different location at the time, which is one of the other houses that I owned. But the fact of the matter is that I was at that house every single day, just about every day for the last 4 years, aside from the July thing. Can I tell you, Judge, what happened in July of the 2006?
Sir, you better talk to your attorney before you tell me anything, okay? Because you're exposing yourself to liability.
Okay.
All right? I don't want to trick you or have it come back that I somehow tricked you into making perjurous statements or...
Your Honor, I have a question, and here's the question. When I read the opposition, it looked like a whole different case. What I had thought...
Counsel, just have a seat. I think I've got a handle on this, and I think I know where we have to go with it.
Do you want to testify about it?
I don't know.
Well, the concern is that the other case that you said in the other case that we didn't know they can hit you on the other one.
Right.
This is more important.
Well, then no, because that's what I said. I think that my other attorney told me that I didn't live there because they served it then, and I wasn't there at the time, so they like was improper serving. Because I would actually reside at that residence. My driver's license says that address.
Right.
But that's why.
Okay, so you just want to testify then?
Huh?
So you want to testify?
They already said that.
Okay.
So yeah.
I guess the way this may play out, though, is they'll say that's a sworn statement, the other affidavit. And if you're saying something different now, it could make you look bad.
I just did what my attorney told me to do because they served the papers to me there, and they served it on my 13-year-old daughter, and they said I wasn't even there, or my 10-year-old son or whatever, and I wasn't even there. And he said
The
they had to
affidavit
decide
was
this. They had to find it, did it, whatever.
The question is,
Look, I don't need to take his testimony today. It appears to my satisfaction that mom has historically been the primary caregiver of these children. That through whatever trickery or beguilement or twist of events, it appears to me that he basically has ceded in some fashion the Merrill residence to her and the children. On a temporary basis, the court is going to award the parties joint legal custody. Mom's going to be designated as the primary physical custodian. The court is going to set child support based on Dad's reported income of $12,000 per month, 31% of which is $3,720.
Your Honor, did you see the tax returns?
I certainly did.
And did you note that after expenses, for this investment...
Counsel, you're $150 away from the cap, okay?
I'm not concerned about the child support as much as I am about the other orders.
Then let me...
There's one more thing you need to know. Your
Counsel,
Honor.
I read it.
I know
I
this.
heard your argument. Counsel, hold it. There are issues that are going to have to be resolved at the time of trial regarding his income, regarding how the money's spent, and regarding what the assets are. I understand it's going to be a nightmare, and I'm very much looking forward to the expert testimony and the voluminous discovery and exhibits that undoubtedly we're going to run into. And so child support is being set based on his assertion that his income is $12,000 per month. 31% is $3,720. That amount is going to be effective starting August. It is going to be subject to retroactive modification based on the information that comes out at the time of trial. Any request for constructive arrears or otherwise will also be subject to retroactive modification. Now, there was a request as well for spousal support.
Your Honor, I have to tell you, she got served with a notice of trustee sale for September 4th, and it affects the orders you're making now. I'm not trying to cause a problem. He stated in his AFC that he just filed in July that he makes a $7,800 a month mortgage payment.
Right.
Here's the proof that he doesn't. She also had her bank account.
Is there equity? And I read that. Is there equity in the home, counsel?
I don't think so.
Look, I mean, here's the deal. I'm going to make temporary support awards, and then either party who wants to can go and file bankruptcy. She may have enough money to stave off or to hold it out. I'm not going to require, in this market, I'm not requiring anybody to try and keep a house if they don't have a positive equity in it. It's just not fair to anyone to try and force them to keep a bad investment afloat. The issue with the home is she's going to be granted exclusive possession of the marital residence, and she's going to be she's going to be solely responsible for the mortgage payment without incurring any liability to the defendant for her failure to pay. Okay, anybody wants to pay that mortgage, they can go ahead and pay that mortgage. But at this point in time, the plaintiff's failure to pay the mortgage payment because the house is already seriously delinquent and in foreclosure will not be an issue that's going to be used by the defendant to claim some sort of an offset at a future date.
I'm not quite sure they're going to foreclose on the 4th.
Now, if he's able to bring the payment current. Okay, current, not just work out something with the mortgage company. If he's able to bring the mortgage current, all the missed payments and the interest and penalties and everything, at that point in time, petition the court, do it ex parte, and at that point in time, I'll make her responsible for the mortgage and have her hold him harmless. How much is the monthly note on the house, ma'am?
$7,800 a month. Her name's not in the note. It's his note.
My name is not on the loan. I don't know what the payment is.
But he noted in his AFC it was $7,800, so I just assumed that that's correct based upon it. Your Honor, that's why, as you can see in the brief, we had a problem with his number of $12,000
I know.
a month, because how could he possibly have done what he did? He had 3 mortgages he was paying.
Counsel, and apparently everything's being foreclosed on.
Right.
The request for alimony is warranted and is going to be approved. The court is going to approve at this time an award of temporary spousal support of $3,000 per month. That is in excess to the child support. The two amounts combined equal $6,720 per month. The entire amount is due for August, before the end of August, and starting September, we're going to require 1/2 due on the 1st and 1/2 due on the 15th. If he's able to catch the mortgage up and files the motion to have her responsible for non-payments, at that point in time, renew a motion to modify the spousal support, and we'll look in at that. If she vacates the residence and you know,
It'll likely be my advice that she'll have to vacate.
Okay.
Council just
Well,
call
she
before
can-
you file a motion, just to at least discuss it first.
Absolutely,
the
Judge.
judge's advice is live there free as long as you can. Save some money up for moving expenses.
Now, Judge, the defendant has been paying her car payment. Since he will be paying $3,000 a month in alimony, will
Yeah,
he-
she's responsible for all of her payments, all of her.
Do I continue to pay health insurance in her name as well? 'Cause I have like a-
Absolutely. You're going to pay health insurance on her and the children. You're going to pay any taxes that need to be paid that she might be liable for. But you probably need to cancel any credit cards that are joint, and each one of you is going to be responsible for your own costs, your own personal expenses from here on out. The request for preliminary attorney's fees, like I said, this is going to be a case where it's going to be needful of a lot of discovery, and it's going to be needful that that the business be appraised. And I don't know, Mr. Taylor, do you have someone in mind for a business appraisal?
I was in the process of finding a rebuttal, so not yet, Judge.
Well, I don't mind having the court appoint one and not having two. It's up to you, counsel.
Well, and that's the issue. If you guys want to save both of you getting one, I think it's appropriate in this case to have one guy appointed by the court and have him do evaluation. If you're
We wouldn't object to that, Judge.
okay, let's go ahead. We'll start off with Nicolaus, and if he's unavailable, then
We'll submit a joint letter to you for you to sign.
yeah, and you know.
No problem, Judge. Can we
Okay.
just do that to Chambers, put the case number on it?
Right, that'll be fine. The defendant is going to be responsible for paying Mr. Nicolaus the ultimate cost of the valuation. It's the intent of this court that it will be equally borne by the parties, and the wife's half share will be dealt with at the time of trial, will be offset against any other fees, property awards, or alimony that she may otherwise be entitled to. The request for preliminary attorney's fees of $15,000 is probably warranted. However, at this point in time, what the court is going to award. You've been paid $5,000, correct, Mr. Mullins?
Yes.
The court is going to award an additional $7,500 to be paid at the rate of $2,500 per month for the next 3 months, and hopefully that'll keep her account somewhat current. I understand there will be additional discovery issues that'll come up, and I realize you guys are still fairly shallow in the case. I don't know if you've designated people that need to depositions and.
We had an early case conference. What I expect is having a second conference, either take counsel lunch or spend an hour with them to outline a discovery plan like the new rules have contemplated.
I think that's reasonable, Judge.
I think we'll be able to do that.
Because typically what I do in order to try and suppress some of the requests for attorney's fees is I require your client to pay for a certain number of depositions, and I'm not sure how many depositions or what we're looking at yet. Before you renew the request for attorney's fees, I'd appreciate it if you'd extend some kind of an offer to the defendant that these are the depositions we need to take, this is how much, and if he'll cover those expenses, then we can just leave the balance of the attorney's fees issues for the time of the trial.
Before we get too far from the child support and alimony issue, he has already paid her, I believe, $4,000 this month, and I believe you said the payments are due on the 1st and the 15th?
Yeah, then the balance is all that's due by the end of the month. If he's paid $4,000, then he owes $2,720. And I think that's it. Is there anything else I needed to address at this time, counsel?
The only main thing is a simple behavior order that says that communication between the parties should be between them, or by email if they don't want to talk to each other. That's fine. But here's the issue that's happening: we have a child that's been thrust in the middle,
Right.
we just don't want that to go further. So
Let me.
if Peter feels uncomfortable.
Anything else I need to address,
The only
counsel?
thing, Judge, we would request that we get an FMC, something so that the children can be interviewed about the potential problems in the home. We could just have a counselor talk to the kids,
I
find
don't
out
have an
what's going on.
objection to that. I don't have an objection.
May I say something, please?
No, wait, you gotta ask me.
Okay.
Who was that?
Gravely.
Have they already seen the
She
counselor?
saw
Because I believe, Judge, the kids have expressed a preference.
Just one time?
They're worried about going one side or the other.
A doctor named Michelle Gravely has seen one of the kids once, and she is used a lot down here. We have no
Look,
objections.
At this point in time, I mean, if the parties want to stipulate, I mean, the FMC does a good job with getting basic facts. They don't do a good job at telling me if kids have been coached or, what's in the child's best interests, or, and they don't make recommendations. It might be appropriate if it's your client's intent to pursue, because I'm going to send them to mediation. And so I was going to hold off until the return from mediation, but it might be perhaps your client wants to have a full-blown outsourced evaluation with a PhD who will interview everybody and submit everyone to the battery of tests. I don't know if he wants to front the expenses for that. I would be inclined to allow an evaluation to take place at this time.
Judge, would you not be interested in seeing what FM Family Court Mediation would have to say?
I am, but like I say, we have issues here, especially with a 13-year-old that I'm not sure your client. I'm not sure anybody's going to be happy with what they get from FMC. I mean, it might be, they might not be. I don't know. If there's, I mean, your client makes allegations that are very serious in nature, and those typically aren't. Even if I have a child telling somebody at FMC that this is what happens, I mean, I've got issues where dad's not reporting it, and I would prefer to have a PhD involved to tell me who's more suitable to make appropriate parenting decisions and where the children are going to be most safe and secure.
I know. Only hesitation, judges.
Well, we'll do the interview first, and we'll send them to mediation, and then, depending on the outcome of that,
An FMC interview?
yep,
Thank you,
and
Judge.
then we'll go from there. How old is Christian?
Almost 2.
He's 22 months old, 23 months
Okay,
old.
so we're not going to interview Christian. Specifically, I'm going to ask the children about allegations of abuse by either parent towards them. Abuse including verbal and physical between the parents. Are there any allegations of drug or alcohol abuse between the parties?
Not that I've seen. No.
No, Judge.
And I'm going to ask the children regarding communication from either parent about the other. Anything else, counsel, that you think
Can you include
directly needs
family
to be
members
asked?
in that too?
Excuse me, what?
Can you include family members in that too? Like mother-in-law, like grandmothers and things like that? Aunts, uncles?
I can, but at this point, I'm not going to hold either one of you responsible for third parties at this point.
Thank you, Judge.
But I am going to issue my admonition. Now, in addition to this child interview, I'm also sending you to mediation. Mediation is mandatory in the state of Nevada. My interpretation of mandatory means that you will make an appointment, you will appear, and you will, in good faith, discuss potential resolution of your custodial issues. You don't have to reach an agreement, but you are the two people upon this entire planet best situated to make those decisions. If you fail to come to an agreement, then you get to come back in here, and between your attorney's arguments and my judgment, we're going to make a decision about how you're going to spend your time with and raise your children. Okay? At any time, the two of you, as parents, have the authority to supersede my order when it comes to custody and timeshare with the kids. And the ideal situation is that the two of you figure out how to co-parent. That doesn't necessarily mean you have to be 50-50 custodians. It just means that you have to learn how to work together, because you're going to be tied together for the rest of your lives through these children.
Your Honor, you're asking, what is going to be the visitation schedule temporarily?
The visitation schedule,
Or you want to wait till after FMC to do that?
no, I'm going to set a visitation schedule now, but there was one other issue. Did you give me the TPO? Oh, I already did the TPO.
Judge, there is a visitation schedule in place right now that seems to be working.
And what is that?
That was through the summer, we agreed to do 50-50 because, as you can see in the brief, he was just keeping them for the half the week anyway. And so rather than have them at their throats every day.
Well, first of all, where is Dr. Balle living?
At the moment, I live in one of my parents' homes. That's a rental house on Okie and Valley View.
How many bedrooms?
3. All 4.
Okay,
3.
and it's an appropriate place for 4 children?
Yeah.
All right. And there's beds and
Yes.
furniture and
Yes.
milk in the refrigerator and cereal in the cupboards?
Yes.
All right.
The last time we had a conversation, there was a guy named Scott Rouleau living there.
Is anybody else living there with you?
No.
All right. All right, look, your days off, you don't work on, do you work on Saturdays or Sundays? You're off Saturdays?
My schedule is very flexible.
Okay. Dad's going to have visitation Friday he'll be allowed, you're going to be able to pick the kids up from school, or do you work
Sure.
until 5?
I can pick them up.
What time do you close your office down on
My
Friday?
office closes at 6.
He does have an employee that
But
can
I have an
cover for him.
employee there, so I can actually leave.
An employee that's a chiropractor?
Yes.
Or?
Mhm.
Okay. So you can exercise, you can pick the kids up from school on Friday
Yes.
and drop them off Monday morning
Yes.
with homework done. Okay, that'll be the visitation schedule until such time as we return. That'll have from Friday after school until Monday at school. If Monday's a holiday, he'll have the children until 10 a.m. That's the other thing. At the bare minimum, if you go to mediation, you should be able to work out a holiday schedule.
That's every weekend?
Yes. And if there are times that you're not going to be able to pick them up, or there's additional times that you need him to watch the kids, this should be your first call. All right. Communication between the parties. I prefer to have it in writing in a manner in which it can be identified who sent it, what time it was sent, who received it. So email, text messages is the preferred method of communication. If either of you decide that you're not going to speak to each other, that's fine by me. Do it through email, do it through text messages, then we know where it came from and who it was intended for. Other than that, the bottom line is, right now and for the next 6 months or so, while this divorce case is pending, each of you is living your life underneath a microscope. Every little thing that you do, every word that comes out of your mouth is going to be twisted, misconstrued, and used against you to make you look like the most despicable, worthless person on this planet. It may not turn out that way, but it has the potential to. So you each are admonished. You need to watch what you say, what you do, how you do it, because everything is going to come back. If there are people in that house around those kids that probably shouldn't be there, I don't care if they're your best buddy from high school, it's probably not a good time to have them hanging around. If you've decided to rejoin the dating pool, it's probably not a good time to have the children exposed to that. I'm not saying any of this is true. Allegations have been made. You two need to realize that at this point in your life, your children have to come first, and everything you do can be placed in a negative spin and used against you. You're responsible for the actions and the words of third parties that are exposed to the children. Your family man, they can't badmouth the children's father. He's their father. Sir, nobody you know can badmouth her. If it happens, you're responsible for it. I don't issue behavioral orders because I anticipate that adults, especially in your social situation, know how to act and behave. If you have questions about what's proper behavior, you better have your attorney on speed dial. Because I'm not going to give you a list of things that you can't do, because heaven forbid I didn't put on there that you can't throw eggs at your ex, and so you think that that's appropriate. Use your better judgment. If I find that it's offensive, it's intended to harass, I will punish you, and it could be meted out by time in incarceration. Is that understood?
Yes.
All right. Anything else before we go?
The only thing I'm concerned about, Your Honor, is she's not gonna get any weekend time at all. Because
This
they're
is-
in school.
Counsel-
I know it's temporary, but
Counsel, it's a temporary order. This is what we're doing until we come back, okay? And we're coming back when?
October 7th at
That's
6:30?
fine.
All right, so it's going to be soon.
Judge, we did have a follow-up question. If the kids have sports events at school or something where both parents could conceivably go or be there,
he'll be invited to attend for sure.
Yeah, they should.
I mean, my son has like football practice
Look,
now. Am I allowed to be
They
at
should
football
both
practice
be
on
there.
Tuesday?
There's no TPO. There's no
Tuesday?
restraining order against either one of you. I've denied the TPO that was requested. Just act appropriately and don't bring third parties. Don't bring somebody that's going to cause problems to any of these activities with you.
Right.
All right.
You guys talk.
Mr. Mullins, prepare an order for me. Thank you.
I'll counsel sign off.
will do.
All right.
Yeah.
Okay, page 5.
And the motion together.
Let's talk about it.
I know. Let's get them.